PowerPoint real quick. And show you. So that's what the principles that I read to you. So you saw space. Let's go in a little bit closer. You can, there is a, for 1 week or 2 weeks out of the year, there is an airport in Black Rock Desert, or you can drive from Reno Airport or from San Francisco, as many people do, however many hours it takes. This, I happen to fly in this year because it happens the same week as school starts, and I sometimes have to figure out how to be both places at once. Then it's a place where I mentioned giant art. So for example, this photograph that I took it from like a mile away. Those are people standing on top of a copper sculpture of a boar that originally rotated and was large enough for lots of people to climb on. It got the nickname Danger Pig or Death Boar because it was massively dangerous, and within the first day they had to weld it in place so that it would stop spinning, because as people were climbing on it while it spun, things happen. You do sign a death waiver when you agree to go. And so the and this is an example of another type of structure. So you have big, this one is something it's electronic, it's LEDs, it's programmed to move, it's interactive in the sense as you walk through it. But then there's also small art. So there's all kinds of different ways that people interact with it. I have also, I wanted to use my own photos here because it's ironic. I don't know, or there's something about an IP professor using other people's photographs that seems wrong, even though I could probably argue it's fair use, which we're going to talk about. But you can see there have been some instances where the organization has agreed to license their or do museum exhibits of art that has been at Burning Man. So this was the Smithsonian, the Renwick Gallery, that is available. If you want to see some more of the art, the Burning Man project itself has galleries where people share their own photos of the kinds of art of pictures that they've taken or what it looks like. So you can see that it's sort of the scale of this, right? Of how large it is, and people are wandering around. The only cars that are allowed on the playa are what are called art vehicles or mutant vehicles, or you can be on bicycles. And so those are some of those. I showed you that. You can also, if you ever wanted to see, they maintain an archive going all the way back of all of the art that they have given that has been installations. They are not the photographs of the art in situ at Burning Man, but usually they are submitted by the person. They might be diagrams or schematics or intended illustrations. This is an example of exactly how it appeared at the playa there, that giant hair pit. So if you want to explore these things, that's where they exist. Okay, so the other thing that's interesting about this, so I mentioned these principles, right? So the principles that have developed around Burning Man that people tend to agree to are these are the 10. So radical inclusion, radical self-expression probably should be the first one, because that's how the whole thing came about, right? A bunch of people got together on the beach outside of San Francisco and they just wanted to make music, make art. And they thought it would be fun to burn a man in effigy because, I don't know, pagan, I don't know, just a celebration. It would be fun to do. And that's where this all grew from, basically from there. And so things that came out of this, again, are this idea of communal effort, leaving no trace, and this immediacy of it. So for many, many years, people weren't, there's no cell phone towers. And if somebody, and there was this arms race between, this may be true or may not be true, but supposedly AT&T and MCI would try to bring little towers to be able to have cell service, and then somebody else would figure out how to jam them. People from NASA go, I have a friend who is with the USAID, and they will come and study how this city arises in a week and then disappears in a week to help inform them and educate them about building refugee villages or post-disaster villages. So there's a lot of things going on there. The thing that's relevant for us today, though, as it relates to copyright, is one of the things is this concept of decommodification, and that You are not you're not selling things, you're not trading things, you're not taking things from here and selling it or using it for advertising. And that is something that Burning Man actually puts into the terms and conditions of their tickets. So in the materials that we have provided for you, I have grabbed some of the relevant terms and conditions from what's very long terms and conditions for a radical, free-spirited organization. But they specifically say that you cannot use any photographs or videos for advertising or commercial purposes, that you can only use them for personal use. You could post them to your accounts, but you can't use them to sell things and make things. And you give Burning Man organization a license in any of those things that you have created. Now, as many artists will tell you, it's really hard to eat if you don't get paid for your art, right? And some of these large scale installations require a lot of material. So Burning Man provides honorariums. You can apply each year to be one of the artists or art collectives that gets an honorarium to build something. Burning Man typically does not assert a right in that art. It's considered your art to go do it. They just get a license for it. They give license to use the photographs. As you'll see, as in one of the cases we provided Chefin, that gives a little bit of the background of, it gives you a glimpse into one of those agreements might look like. And so some of the art has been then subsequently commodified in the sense that, like, for example, there was a space whale, and that now graces the entrance of Reno because the artist got an honorarium. And as happened with the Spanish galleon that's mentioned in that Sheffield case, many times the honorarium doesn't even come close to covering the cost of creating the piece of artwork that is taken there. And so sometimes people find other ways to be compensated, whether it's having a GoFundMe or doing a Patreon account, or later allowing someone out, giving a license or selling it outright to live somewhere like the front of the airport of Reno. All right. The terms and conditions for the ticket for Burning Man are they've been lambasted, I would say, by the Electronic Frontier Foundation for how tightly they grab control over images and videos taken at the event, and that they give people DMCA takedown notices. But they say, they stand by. They have made some changes over the years in response to that, but they stand by that they are trying to protect the privacy of the people who are participating in an event that is meant to be self-expression and immediacy, and as well as protecting the artists who have put their creations out there. So I'm going to stop there for now and take a breath. And let's see, Dusty gathering. It's like no ritual sacrifices. Yes, the things that get sacrificed are wood, and you have to get approved to burn something, and there are very strict. You can't have any paint on it. You can have whitewash, but you can't have paint because it creates a toxin when it burns. So these are the 10 principles. And so I wanted to, and I've had conversations with both artists at Burning Man, outside of Burning Man, and other lawyers about this, and about how you could have a weeks-long conversation about how do you decommodify? Is that possible? Where do we draw that line? Isn't it commodification if that whale got sold? Isn't it commodification when I get an honorarium? But nonetheless, we will still try to hew to these principles generally, and at the same time encouraging artists to make art. And I think it becomes more intention with copyright law, because we're talking about US copyright law, which doesn't have the same history of respect of the artist's creation that we see in Europe and the moral rights. So I thought that there were two hypotheticals that I thought would be useful to explore. Also, too, all of the crazy implications of copyright embodied in Burning Man. In the process of doing this, I realized this is probably a semester-long course in copyright. So I'm going to fly through this, and I just want to, and we may not have all the answers, partly because there aren't some of the things like, as you might know, the question of what is the lines between derivative works and fair use keeps moving, and it depends on which state you're standing in and which circuit and what mood the Second Circuit's in. But we're going to talk about it anyway. All right, so moving ahead. So the first hypothetical is actually not hypothetical, it really happened. A longtime burner who was a fashion designer decided that it would be a good idea when he got back from Burning Man to take images from Burning Man and put it on his clothes at the Paris Fashion Show. Well, so the Burning Man org was not amused. All right, so this is zooming in on these pants here. What you see here are images of art that was actually on the playa that year. It was 2017. This is a sculpture that was on the playa and that was eventually burned. I will show you. Let me show you what the actual one looked like. Where'd it go? It's over here. That's it burning on there. This is what it looked like as it burned. You can see kind of the scale of it. And there were many other installations like that on the pants. All right. And so the other thing that was on the pants was these writings that you see. Let me go back page. These writings you see came out of what's called the temple. I mentioned the temple. Well, there's the man, and that usually burns on the Saturday night of the week-long celebration, which ends on Sunday. And then over time, as people died or things happened, there became this need for a contemplative space as well. And so they began the ritual of adding a temple that would be burned and would get an honorarium to be built and burned. And this became sort of a sacred space. If the man burn was like a pagan ritual with loud noise and partying and having fun, then where'd it go? I lost my temple picture that I had. Nope. That image that I had showed that was sort of like, it looked like a giant anthill. Well, that was the temple, and people began to bring offerings and make writings, and they would like leave notes to people who had died or tell them that they missed them. And these pants are taking those actual writings, in addition to using these images from the playa. So the question for you is, if your client were Burning Man and they like, this goes against everything we said, don't use images, don't use photos and videos to sell things, to commodify it. And here you come home and you took everybody's stuff and you're selling it, and we have to stop this. How are we going to stop this? So I'd like to open it up and say, what suggestions would you have? What could Burning Man org do to stop this use of all of these images and this information? And I will take a look at the chat at the same time to see if there's anything, if y'all have some suggestions or thoughts. I'll give you a minute. And there we go. What recourse do we have? All right. All right, maybe people have fallen asleep, or you are all looking at images of Burning Man on the web. All right. TNC of the tickets, thank you. Were they assigned the rights? Breach of contract. Maybe you guys you're taking the time to type. Sorry about that. Right. Okay, breach of contract. Were they assigned the rights? Were they works made for hire, the terms and conditions of the tickets, which is contract, yeah, breach of contract claims. So all of these things are definitely possible. Now, the thing is, we have to delve into copyright law though, too, right? Because if we go to the terms and conditions of the tickets, it says that you won't use your photos and it won't use your videos. Now, it looks to me like these might be illustrations. and not actual photos. So we might have to dig into that. And if Burning Man doesn't assert any copyrights in the works of art that are made there, they may not have that. So it seems like even with the contract or the implicit contract in this agreement that we will abide by these principles, we still have to go digging into copyright law. Right. So, excuse me. So copyright law, and especially when it comes to Burning Man, becomes this big, hairy, crazy, like, I don't even know where to begin to analyze this problem, right? So, we have, when I try to break down these problems, one of the things that I want to do is let's start from the basics. So let's say, is it protectable by copyright? What in there is protected by copyright? Because some things are not. Now, I know you all are all IP practitioners, so I don't want to insult your intelligence, but let me remind you of some of the specifics of copyright law, right? So copyright protection subsists in original works of authorship, fixed in a tangible medium of expression, and then it's got to fall into one of the categories. So if we take a look at those categories, there's literary works, don't matter, musical works, we're really concerned about pictorial, graphic, and sculptural works, right? So if we take a look at this, well, let's see, people's writings on the walls of the temple, would those be protected by copyright? Is that even copyrightable? They're really important sentiments to those people, but they may be too short, not creative enough. They may be the short phrases that are too short to be protected by copyright. Then we also have think about some of the other artworks, like the giant sculpture called Embrace. That was the two people that was set on fire, right? That sculpture, well, that looks like a sculpture. So that's probably protectable by copyright because that's under one of the categories. But let's look at the temple. Right. So the temple, is that a sculpture or is it a building? Is it a place where people not dwell, they don't live, but is it a commercial building, right? Or not a commercial building? Is it a building, right, in the sense that it's a place where people go but don't live? Is it an architectural work? Now, thanks to since 1990, architectural works are protected, including the plans themselves. But they have different kinds of copyright protections. There's some exceptions to what can be done with them that might be a problem for our client. So architectural work, temple could be an architectural work or it could be a sculpture. We'd probably have to dig into that a little bit more. The writings inside the temple, possibly, assuming they're not too short. Well, the sculptures that are out there, they're definitely protected by copyright because they are sculptures. So then we get to but who has the right to enforce those? So copyright ownership, copyright vests in the creator of the work, unless it's a work for hire, right? Or unless it's a joint work or a collective work. So things that are a work for hire, and again, I just want to remind you of these details, that a work for hire, right, has to include yeah, absolutely. You could go after both of those issues. You could do copyright infringement and breach of contract on that. But so it has to be a work for hire is if something's created in the course of your employment and it's what the employer pays you to do, then the employer is the owner. Or if you're an independent contractor, you're not an employee, and somebody commissions you or hires you to create something, there's a writing in place before the work of art or work of creativity is created, and you agree that it's a work for hire and that it's one of the 9 specific categories of things that are work for hire, which do not include sculpture. They do, however, include things like pulling up, I want to give the exact right words here for you all. I've lost my notes on that, but so work for hire. So things that, so there's collective work. So if it were a collective work, then that might be considered, but it's not going to be, it's not a map, it's not a test answer. And so many times, even though it's a work, it might be considered a work for hire. There we go. Work specially ordered commission for use as a contribution to a collective work, motion picture, translation, supplementary. So a whole bunch of things that don't apply here. So whether those are, so even if the artist got an honorarium from Burning Man in order to build something, it probably wasn't a work for hire. And if the honorarium didn't even cover the cost of the materials to create it, it probably is not a work for hire, as we saw in the Sheffield case. And Burning Man rarely asserts rights in the art itself. So it's probably not a work for hire. So we assume then that the artists themselves who created these works are the ones who have the right to assert, to exert control over the use of their art. The author of the works, the author, whether that's the person who created it or the person who owns it by law as the work for hire or the employer, has the right to use the work in many ways, including the derivative works. So derivative works, of course, have a statutory definition, and they include things such as taking the work and putting it into a different medium, right? Taking the common example is you take a book and turn it into a motion picture, right? That's a derivative work. Now, or to make copies of it, to make multiple copies of it to distribute. So if we are advising Burning Man organization, we're going to say, all right, well, we can't really do anything except to the extent that we have some rights to assert as a work for hire, or that we have a license, or that the terms of condition, we would have to take a look at the contract that we had with the artist to whom we gave an honorarium. Did we, and I don't have access to these contracts, they're not publicly available, but if we go based on what's in the Sheffield case, the Spanish galleon. And in case you didn't have a chance to read this, it's an interesting case because it implicates the Visual Artists' Rights Act, as well as a thing that was built for Burning Man that got burned not on purpose. Well, it was burned on purpose, but not because the artist wanted it to be burned. And so in that case, artists had created one of these mutant vehicles or art cars that began life as a school bus. And they built a Spanish galleon around it so that it could travel around on the playa and people could ride on it. And they received an honorarium from Burning Man to build it, which essentially was like a helps, a starting help hand to start getting it built. And for many years, the galleon did come to the playa each year and rode around. And then the artists, I think what I can glean from this is that they had a dispute with Burning Man, said it wasn't operated safely on the playa. And so they couldn't come back because they must have been given a bunch of warnings about how they were operating the Spanish galleon on playa and didn't pay attention. So they had a friend and they left it with her on the land where she lived, which it turned out she didn't own the land and she left. And so basically this bus, now Spanish galleon, got abandoned on the property. The person who came to own the property says, I don't want this here anymore. They send a notice, but they send it to Burning Man that says, come get it or we're going to burn it so I can get to the scrap metal. The artists who say they own it didn't get that notice. It gets burned. They are trying to be compensated because they said they spent approximately $15,000 building this thing, or $15,000 to $30,000 building this thing. So they come to court and they bring a claim based on the Visual Artists' Rights Act, which was passed in 1990 so that the US could join the Berne Convention, and we had to agree to adopt some portions of the moral rights concepts recognized in the Berne Convention and recognized in Europe. So the key points of that are that we are trying to, it's instead of looking at copyright from the US perspective of we're trying to encourage people to create things and to create derivative works of things so you can do things that are fair use, we are going to instead, we're going to recognize also too that an artist has an inherent right in something that they have created. And so it cannot be destroyed or mutilated or harmed in any way without their permission or input. And the artists of the Spanish Galleon tried to bring this case. The Visual Artists' Rights Act, or VERA, applies to pictorial, sculptural, and visual arts, and it does not include applied art, which the court ultimately held that the Spanish Galleon was actually applied art, that it was utilitarian, it served a function of transportation, and that the ornamentation was incidental, but its primary function was to provide transportation, so that they had no standing under the Visual Arts Rights Act. So we look to that to say, can we perhaps then use this to stop the fashion designer? He's taking art that was created on the playa and mutilating it. He's putting it in disrepute. He's using my name and my art in a way that I would not approve of. We have a few other cases we can take a look at. The 5 Points case in New York, where the graffiti was destroyed, as another case where the artists were successful, but the art was destroyed. So it was an after the, sort of a Pyrrhic victory after the fact they get compensated. But the thing that makes it possible for you to get protection under that act is not just that you had created a piece of art that that got destroyed or that could be destroyed. It's that it has to be of note. It has to be recognized as a piece of work that has and these terms aren't defined in VERA, right? So they talk about, and that was one of the things that was a challenge in the 5 Points case, is that they had to bring on experts to say, is this a notable piece of work of art? Is this a recognized artist? Is this something that will be that is worth protecting, if you will? So I'm not sure that VERA is going to help us in this case. With the temple, for example, the temple that wasn't actually represented on the pants. It was the writings within the pants. The artists agree to have the temple destroyed. It is burned at Burning Man so that it no longer exists. So it may not be that they can stop somebody else from using these works in another fashion like that. So then we try to take a look and say, okay, is it a derivative work? Is this a derivative work that the original artist should have been entitled to use? And at this point, this is where your fashion designer brings up fair use, right? So we get to wade into a whole nother hairy part of copyright law. So let me ask y'all, do you think that the fashion designer's use of these images on the clothing, was it fair use? Thoughts? No commercial impact, why not? Okay. So somebody else says, but it is commercial in nature. Okay. Profiting from work of another, it could be marketed. Not fair use because he's a designer or just an artist. An interesting note is that this artist had actually received honorariums from Burning Man to build art on the playa before. He did that, and not fair use. Oh, I stumbled for a minute with the FU there because the entirety of the personal messages was used. Okay, so the personal messages, right? Yeah, so saying that's not fair use. Maybe parody. Is it parody? Is it commentary? Right? So we have to take a look at, again, in these defenses of fair use. You can use, you've got the 4 factors. It seems transformative. So Becky says transformative, at least as much as some of the art projects held to be transformative, looking at Prince, the Rasta book, et cetera. Okay. Yeah. And so Lisa, based on the Carrot case. So reminding people about these cases. So we talk about fair use. All right. I want to stop for a second. I want to stop sharing for a second and just remind ourselves about fair use and what we're talking about here. So Carrie of Prince, let me throw up here for the let me share this with you all as a reminder. There we go. All right, so you look at the purpose and character of the use, and whether it's commercial use or not, or a nonprofit, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect on the potential market for the value of the copyrighted work. So copyright law, the case law is all over the place on this, and we'll talk about, so somebody mentioned Carrie Prince, right? So Carrie was the photographer who took photographs of Rastafarians. He spent years doing this and documenting photos. And then Richard Prince, a very famous appropriation artist, did this thing and appropriated that and made collages of these photographs with his drawings on top of them, and then did a book on them. And so Carew sued on that. So originally in that case, it was some of the court did find that some of, not all of the photos had been transformed enough, and that it was commentary on the underlying photos. Now, this is debatable whether that's true or not. There's a really interesting podcast called Art and the Law, depositions of Prince, that he wasn't thinking about commentary. He likes marking things up. He sees something and he wants to make a picture. He does it. He doesn't think about commentary at all. Now, CF, the recent decision in the Warhol Foundation case versus Goldsmith, she took a photo of Prince years ago that Vanity Fair had licensed. And then Vanity Fair wanted to do a picture, they were doing an article about Prince and fame, and they commissioned Warhol illustrations, and they used this Goldsmith photo as the reference photo for that illustration, and then put it on the cover of Vanity Fair. So Goldsmith sends a cease and desist letter to the Warhol Foundation. The Warhol Foundation seeks declaratory judgment to say that it's not infringing. They think that this is clearly fair use. And so the case goes on and it gets appealed, and a decision came out just not too long ago. So the court has held and overturned the lower court, saying it was not fair use. And the lower court tried to just skipped over deciding whether this was infringing or not. Were these substantially the same? And if they're substantially the same, do we then bring in the defense of fair use? No, the lower court just went straight to, is it fair use? And this gets appealed, and the appeals court says, well, we're going to, in their decision, they're like, oh, no, we have to talk about substantial similarity first, even though the lower court didn't do that. And they did hold that it was substantially similar. And they also used this as an opportunity to course correct the misunderstanding that they think has been coming out of with the Carew v. Prince case, and to say that any marking, any change is not necessarily transformative. It has to be commentary. It has to be saying something. It has to have some meaning. Merely putting a mark on something isn't enough for it to be transformative alone. Okay, so I don't know that it's going to clarify anything. Other courts, Seventh Circuit, don't agree with the Second Circuit's version of fair use. And some commentators and courts think that we've gone too far with fair use anyway. Right. So anyway, so all of this to come back to, is this fair use? Is it transformative? Is he making a commentary, or is the designer, fashion designer, making commentary? Or is he just collecting his favorite images and putting them on clothes? And yeah, it gets down to, and the other thing that that factored in with the Warhol case was that while the two parties were making an argument that, and the Warhol Foundation was making the argument that a Warhol painting in and of itself is a commentary. Like, that was the whole thing of what he was doing, was talking about celebrity as a mass marketed product. So the very fact of doing a Warhol of a photograph makes it's a different market, millions of dollars, thousands of dollars for the photo. And it is in fact commentary. But then the court goes down to, but wait a minute, both y'all were licensing this to Vanity Fair to sell magazines. It's commercial. And it was the same commercial purpose for both of you. So that's another thing that we can take a look at then with the fashion designer. Was it a one-off? Did they sell more of them? I think somebody said that in the chat. Or was it just the one time? Yeah, was it actually produced or sold, a one-off thing? Maybe it's more art than commercial. So yeah, so it still could potentially be art. So now we have this interplay of, all right, whose art's on there? Does he need to have license rights? And does he need to have permission? I just said 3 words in one sound. Burning Man Journal, which is the blog for Burning Man, had a commentary on this. And they're like, yes, we've heard about this. Yes, we know it's bad. We don't like it either. They reached out to the artists whose art was on the pants, and they discovered that some people had been contacted and had given permission. Some people have been contacted and said, no, you can't use my art, yet it showed up anyway. And some people had never been contacted, but they didn't really mind so much anyway. Now, they offered to help people assert and to affirm their rights. I think that a conversation must have ensued with the fashion designer, and then things got ugly for the fashion designer. I can't say that they're related to this. We just see that there's a bankruptcy a year later. So I don't know if this played a role or not. So it doesn't get tested in court. And I don't think that Burning Man has any recourse under the terms and conditions of the ticket, because it's not, if they're not photos or videos. So I'm running out of time. We got started a little bit late, but that's all right. I had a second hypothetical that I just want to show you some of the pictures, but while I'm pulling that up, any other thoughts, comments, questions? If you want to throw them in the chat or speak up, I'm happy either way. Sharing screen with PowerPoint. There we go. Oh, thank you. So I've been given a reprieve on the time. So in the packet that we gave you, I did give you some of the relevant documents. I gave you the tickets and terms, conditions, I did not put the copyright statute in there. I figure that's a little long. We talk, and then some of the cases that we're talking about here in terms of fair use, Campbell v. Acuff Rose, which is one of the ones where we talked about parody, and they took, so actually they took the piece of Pretty Woman into the rap song, Visual Arts Rights Act. So we can also take a look at this from the other side of if it's an artist who has put something on there. And this is called the Mega Cake. It was built in 2019, the last Burning Man before the last Burning Man in-person Burning Man before the pandemic. This is the architect's rendering. It was built by a artist collective, which included me. And it is 65 feet. It was 65 feet tall. It's made out of wood. It had a spiral staircase that went up. These were little candles that had gas that poofed and burned. And there's slides, and then various artists contributed different things. Each of these little pink triangles were actually glass made by a glass artist and etched with different zodiac symbols. And there were different pieces of art that were contributed by a bunch of different artists, plus the people that this artist collective that came up with the idea and built it. So this was burned intentionally during the week of the burn. And we have a couple of photographs here. This is what it looked like as it was burning. I do not have a picture of with the fireworks. It was too much happening and it's hard to get pictures of fireworks, but there are some photographers that got really good pictures of the fireworks. They also have pictures of fire tornadoes coming off of this. So we have the artist collective, we have the lead designer. This thing doesn't exist anymore. And he's had people from this collective come to him and say, well, what do you say? I want to sell this photo of it. How about that? I think it's going to make great calendars and postcards. And somebody else has said, let's do it again. Let's build it next year. And they're like, no, we're done. We're so tired. We did not get an honorarium. We raised money and a lot of people reached into their pockets to do this. So the question becomes then, what rights does the lead designer have? What rights does the collective have? And what can they allow and not allow? And who owns it? So as many things do, often come down to, is there a writing? No, there's no writing. There is no agreement between the members of the artists collective. There is no contract with Burning Man. They just said, don't put paint on it and get the fire marshal to sign off of it and agree to comply by these rules. But basically you, the artist, own that. So copyright questions, it doesn't exist anymore. Does copyright still exist in this thing, the structure that is no longer built? Yes, the answer is yes, it does. Because just like a book, right? The book is the copy that is the physical, tangible embodiment of the novel that is written down. So the art, it was the tangible representation. But we do get into interesting questions of whether, was it sculpture or was it architectural work? Because that's the other thing too, is like photographs of architectural works are not considered, you can't restrict those. That's part of the statute. Was when we added architectural works to the statute and say that people could have rights in those, we did say, though, if you take a picture of a building in public, you cannot be sued for copyright infringement, and that's not considered a derivative work, so that we don't get in trouble for taking pictures of the fronts of buildings. It's used to its detriment in a case in, let's see, this was in California, and there was a building that was used as the second bank of Gotham, and there are sculptural elements, and the courts decide that that is architectural work, even though the sculptural elements arguably are separable. You have other case law that goes the opposite way. So another unsettled area in terms of that. Nobody lived in the cake. So I don't know if it really would be considered an architectural design. It's not really a building. It's not, people weren't meant to stay in there or spend a significant time in there. I think it's more of a sculpture. So you might be able to protect and restrict the use of derivative works of photographs of the elements. There is another case, however, that has also too, like if you took pictures of the fireworks, is that protectable? Probably not. It's ephemeral. So I'm going to stop there. I've got a few minutes to spare. I'm happy to entertain comments or questions or thoughts anybody might have. I'm going to stop share there. Oh. Yeah.
What, Professor Dobbs, you want to give it just a minute to see if anyone has a question they want to type in or they want to pop up on the screen and talk to you directly?
Absolutely.
And if not, then I wish I had the is it the Jeopardy music that goes ding ding ding? I feel like it's
that's exactly right. Exactly right. Well, I was doing this with my students today. I'm like, I can, actually I'm not very good at the silence waiting for people to ask questions. I'll just keep talking. But I think this, tell you a crazy Burning Man story.
Ooh.
What happens at Burning Man stays at Burning Man? No, I mean, I don't know. Everything, right? Everything is crazy. It is, I will tell you, it's, The death boar is the one that kind of blew my mind, right? There's a phrase, the safety third, Burning Man. And that's a classic example of it. Like somebody called it the finger cutter, and that's what happened. Somebody lost a finger. So they welded it so it wouldn't turn anymore. So and the idea, the things that people create and that come up out of nowhere. And there's also this, there's this serendipity that occurs as well, that you don't know what you're going to find. Sometimes you just go off and explore and you're like, gosh, I wish, I wish I had a pancake, and somebody on a bike rises up next to you and says, hey, you want some pancakes? Oh. What? All right. Amazing. Okay, so I do see a question. What if I marketed pants that were basically like that pair of pants and started selling them and called them Liar Liar Pants on Fire brand? I love that. I love that. Could the pants designer sue you? Well, let's say, okay, so let's assume for argument's sake that the pants designer has rights in their creation. Let's assume let's put back, like, did they steal it or not? Let's assume they do have rights in it, and you created and you copied them. Well, it's a substantial similarity. It's the same. It's not, are you thinking that perhaps by giving them a different name that's commentary? Maybe. Like, so that's like Carews Marx or Warhol's taking an image and making it flat and making it mass produced to be commentary, possibly. I think you would have to do something that would have to be on the pants themselves. It can't be the name of the pants, because if the pants are the art, right, then that becomes what the image is. And the other thing too is, remember too, copyright does not protect fashion design. It protects what's printed on the fabrics at most, right? But if you stole the designs, I don't think you have any rights in anything. But then does that mean that you are now, have you taken out the middleman and you are infringing on the artists who are pictured on that, and you're just continuing the liability, much like Napster, right? Should I steal from people stole? No, two wrongs don't make a right. You know this. I don't need copyright law for that one. I have actually, it's been really quite interesting to me. So I first learned about Burning Man when I lived in Southern California. None of my friends wanted to go. They're like, that sounds terrible. And so I really was interested in the anarchy aspect of it. And I learned about the big art. And that's when I've been like, I want to be part of, I have very rarely seen, and not until the Smithsonian exhibit came to DC had I seen art on that scale in the public. So there is some public art, like think about the Wall Street Bull and the little girl commenting on it, but usually you're not supposed to touch it. So it sparked an interest for me in creating interactive art. Yes, please touch the art. How can we bring the participants, stop being observers, stop being an audience, and be part of the art? How can you help create the art? How can you have something that is ephemeral and immediate and creates an experience for you that cannot be captured? Or how can we capture it? Other questions? Has the Burning Manager ever secured potential to get something based on IP provisions of the ticket agreement? That I have not found anything to that. So far of the cases that I have seen, they've been enforcing their trademark. There was a dispute over who owned the electronics in an art piece that was commissioned and they not necessarily paid for. But I have not seen, if they had a case like that, I have not been able to find it. And I have to tell you, I take great joy in being able to ask my law school librarian to help me find cases about Burning Man.
All right, with that, everybody turn on your videos. I guess it's time for us to network. Professor Dobbs, again, thank you so much for coming and talking to us. You are very welcome, as we would invite our in-person guests and speakers to stick around and network with us as well. But if you find us boring, then you can leave.
Oh, thank you. Well, I can stay for about 10 minutes. I'd like to. Thank you for the invitation.
Then I'll let the magic of Zoom sort you into a breakout room and where you can, you can